Good morning, hello, and welcome to today's webinar. Today's webinar on behalf of the CIPD HR Inform is Managing Annual Leave in a Company. It's the 12th of November. My name's Amanda Chadwick and I'm a speaker. And today we are going to talk about managing the annual leave, which a lot of people do have questions about because it involves so many different types of contracts and people. So, okay. Please note, so this is the first thing, the detail contained within this webinar is based on GB employment legislation. So we'd ask that any clients in the jurisdictions of Northern Ireland, the Republic of Ireland, Jersey, Guernsey and the Isle of Man are asked to please contact the advice service first to obtain the information relevant to your jurisdiction. So the objectives of today are to gain practical advice on how leave entitlements vary depending on the hours worked, how leave should be requested and taken, areas that can impact upon entitlements and holiday pay, and untaken leave at the end of employment. Now, remember a few years ago I did a seminar, and we were just doing a seminar with an overview on employment law, and somebody from the care sector asked a question about holidays, and it took 45 minutes of the presentation up because once you get into the calculations, it sometimes becomes quite difficult. Well, it did in those days because there wasn't any calculators available on the internet, but now through the CIPD HR Inform you can access a calculator. I'm sure there's calculators all over now to work out the pro ratas, but what we have to remember is it is relevant legislation. Holidays are there for a reason, so it is a working time, I would say, well, European Term Directive, Working Time Regulations 1998 as amended, and an Employment Rights Act in 1996. So the Working Time Directive, as you know, if you don't know and you're listening, because we have all levels of learning here, is the European legislation that compelled the UK to implement laws relating to minimum periods of paid time off for workers, a right that we have to have because we spend so much time at work awake that we need to have rest time. And now we know the importance of having that work-life balance and holidays, because we have 15.4, I think it's million employees off sick at the moment with stress and depression, and you know, a lot of them citing that it's work related. So we have to do our bit and allow people to take the holidays. It is their right, ensuring that they are taking them. So the Working Time Regulations 1998 as amended was the domestic piece of legislation that introduced minimum annual leave. So before this law, there was no minimum annual leave that had to be given. It was all down to what was in the contract. So, you know, what the contract is, it's when I come for an interview with you, sit down with you, and you tell me how much I'm going to get paid, what hours I'd be working, are my statutory terms. The Employment Rights Act 1996, this is where we need to look when we are talking about holiday pay, and also because it sets out the requirement to include information on annual leave in the statement of main terms of employment. That statement of main terms of employment is absolutely crucial. At the moment, the law says you have to issue it within 8 weeks of employment, but the Good Work Plan is stated that next year you should issue it from day one, which is what I've been saying all along. You know, when you apply for a job, you want everything to be confirmed in writing. So the Working Time Regulations are primarily a piece of health and safety law. The whole aim behind the regulations is to provide workers with a sufficient amount of paid time off so that they do not burn out. Annual leave is to allow an employee to rest. The fact that it is paid is because the government do not want people to be put off from taking their rest if it leaves them in a less favourable financial situation. And I don't know if you know this, but the working time claims were the most common claims submitted at the Employment Tribunal between April 2018 to March 2019. So this shows that employers are getting these rights wrong. And I know that you'll be listening thinking, what? People get that wrong? You know, holidays? Yes, they do. They get the holidays wrong, they get the breaks wrong, they get lots of stuff wrong. But you can imagine now with the employment tribunals of stress and depression and the increase in it, more and more people will be citing that they didn't have the breaks, that they weren't allowed to take holidays, and they didn't have breaks in between. So it's very important to understand the working time regulations. So who is entitled to statutory annual leave? So you can see on the left there, we've got employees, part-time workers, fixed term, workers, 0 hour, variable hours, agency, apprentices. And then the ones that aren't entitled to the statutory annual leave are the truly self-employed. So if you can remember just recently, the case with the Lorraine Kelly, with the HMRC, how she won that case was producing what we call a contract for services. So if you are listening to me today and you don't really know, or you think that you have truly self-employed, or you're questioning yourself because there's been lots of publicity, like the likes of Pimlico Plumbers, Hermes, etc., you know, whether somebody is genuinely self-employed or not, it might be worth ringing us up to just double check. Lorraine Kelly, she won her case by producing a contract for services, and what the HMRC said to her was, you know, you owe, I think it was over £1 million actually, and they said, you host the Lorraine show, you are not a self-employed employee. You're definitely not a self-employed employee. You are a worker or an employee of ITV. And Lorraine Kelly produced this contract for services and said, I'm not paying you the £1 million. That was my Lorraine Kelly voice, by the way, for the morning. But she said, I'm not, you know, I don't owe you that money, and I'm truly a self-employed individual. On my contract for services, it says I do work for other people, not just ITV. It says I pay my own tax, my own national insurance. It says that I don't just rely solely on ITV for the income. It says that I don't I work for several employees. I have my own company, and the right of substitution, you know, that I can send somebody else in place to host the Lorraine show, and ITV have done that. And she won the case. So if you're querying what self-employed is, what you don't want to do is get it wrong and then end up in a tribunal where somebody says, well, I've worked with them for 10 years now and I'm an employee, and they're saying I was self-employed all along. So it is one of those questions that you need to clear up. Truly self-employed volunteers and children, anybody using volunteers, you need a volunteer agreement in place. So all of those entitled to take annual leave begin to accrue it. So we now know from the first day they start working for you. The old law stipulated that accrual did not begin until the 13 weeks in. However, that rule is long gone. Basically, anyone who is under a contract to personally provide services is entitled to statutory minimum paid annual leave. Agriculture workers are entitled to a statutory minimum amount of annual leave, but this tends to be more than that set out in the working time regulations. They really do have their own laws, which really generally provide entitlements in excess of their usual countrywide ones. However, we are seeing the situation with agriculture workers change, and it's changed quite a lot in the last few years. And so the situation can differ depending on the location within the UK and what the workers' start date is. So anybody who does employ agriculture workers, give us a call to clear that one up. Children, so that's under compulsory school leaving age. And if it's anything to do with my child, my youngest one, she definitely wants to leave school at the age of 15. She's had enough, and I'm trying to keep her there at the moment. So I don't know if that applies to her, but children, those under compulsory school leaving age, are not considered to be workers by the law, and so are generally not covered by normal legislation. So holidays aren't entitled to. So this means that they're not entitled to statutory minimum paid annual leave, but they are entitled to have a 2-week period in the year in which they are not in work or at school. So there is no legal entitlement to pay during this time, though. So statutory annual leave entitlements. So we've got the minimum of 5.6 working weeks. So most employers express this really as 28 days, and then workers book in annual leave in terms of days. So however, Operational reasons may mean that it is better for you to calculate the annual leave in terms of hours or shifts. We see this in the care sector and retail as well. And all of this is possible. It just needs a bit of mathematics, which isn't my greatest subject, so I'll be completely honest with you, but it is entirely possible. Working it out in hours may be better for someone who works a different number of hours on different days. So if we look at that, for example, if someone works for 7 hours on a Monday, Wednesday, and Friday, and 3 hours on Tuesdays and Thursdays, there is nothing that is a consistent day for them in terms of working hours. So you can calculate the number of hours due by multiplying how many hours they worked in a week by 5.6. And then they would request their leave in terms of the number of hours they want. So I hope you understood that. What the 5.6 working weeks entitlement means is that employers must allow workers the opportunity to take this amount of annual leave. Some workers choose not to take all of their leave. All the employer must do is ensure there is an opportunity for them to take it. So this means that you should be doing periodical reminders throughout the leave year of how much each worker has left, which is an absolutely brilliant idea. You might remind people on the pay slips, for example. The 5.6 weeks can include bank holidays and public holidays. And those who have been around longer than others, the statutory minimum was 4 weeks, if you remember, 20 days for a 5-day. So we've got to remember that that's what we talk about with the statutory annual leave entitlements. But if you remember, if you have been around a long time, the government found and acknowledged that employers were counting the usually 8 bank holidays in the 20-day entitlement, leaving actually only 12 days for workers to take by choice. So I don't know if you remember, and you've been around that long, in order to remedy this, minimum entitlement was increased to 4.8 weeks in 2007. My goodness, it doesn't seem that long ago, does it? And again to 5.6 weeks in 2009. The extra 1.6 weeks signifies the 8 days of bank or public holidays, but the reason we don't list it as bank holidays or public holidays is because a lot of people out there work on those days. And of course, if you are listening in Scotland, and I really apologise for my Lorraine Kelly voice, the number of bank holidays is greater, so I think I might be moving up there. So part-time employees. So part-time employees, are still entitled to the 5.6 working weeks leave. It is just the 5.6 times what their working week is, which will obviously be less than a full-time worker. So it's prorated. Employees should apply the pro rata principle and set this out in the contract. So you need to write that down. So this means the number of days leave will be less than a full-time worker's. And protection from less favourable treatment. An example of this may be that if a full-time worker gets contractual leave in excess of statutory, then to deny that to part-time workers would be less favourable treatment. Obviously, the contractual excess can be watered down. So the other thing with part-time workers is if the part-time worker works different numbers of hours each day, which is quite often the case, calculation can be carried out in hours rather than days. So again, part-time employees are still entitled to 5.6 working weeks leave. It is just 5.6 times what their working week is, which will obviously be less than a full-time worker. And part-time workers, as I said to you, are protected from less favourable treatment. And the example of working out the week, a worker works 3 days per week. So it's 5.6 times 3, and it equals 16.8 days per leave year. Then it gets complicated again. Oh, variable or 0-hour workers. So previously, employers have calculated paid holiday entitlement for employees with variable hours as 12.07% of all time worked. However, we have a case, the recent case of Harper Trust versus Brazil, I hope that's Brazil, has cast doubt on the validity of using this method. And this case found that calculating holidays for part-year employees should not be prorated down in this way, as they were still accruing annual leave when they were not working. So
So when we look at the part year workers, the claimant in the Harper Trust case was a music teacher who worked at the school for 32 hours per week between 32 and 35 weeks per year. She worked at the school on a regular basis as part of a 0 hours contract. Other examples include seasonal workers who are only required for parts of the year but kept on permanent contracts. So this has raised the question as to whether this should also apply to those who work variable hours. And if you need any further case law on this, or you want to look in depth to the Harper Trust case, what you can do, we can help you with this, but what you could do is go on the CIPD HR Informed site, and we have lots of case history on there. So, but for now, we should carry on prorating down entitlements. So let's just note the Harper Trust only applies to those who work unusual hours but are on permanent contracts. The court did accept that this ruling could lead to odd results in extreme cases, such as school cricket coach who only worked for part of the year being entitled to significant holiday pay that would exceed that of a full-time staff member. So when taking into account the number of hours he actually worked, however, they stated that it would be unusual for an individual who only worked a few hours a year to be on a permanent contract. I don't think you do that anyway. But as I said, with variable or 0 hours, speak to us. Don't just guesswork on this. Speak to us and we'll give you clarification on this. And then what we've got is public and bank holidays. So the time off depends on the contract of employment, really basically what you've got written down. And I always say this to people, if you are taking advice off anybody, read out what you've got written down, because what you don't want is a breach of contract claim, which could be heard from day one. And you don't want to breach your own contracts. The advice you should be getting should be conducive to what you've got written down. So there's no automatic right to time off on a public or bank holiday. So contractual right depends on the nature of the business. Example, retail workers will generally open on a public bank holidays and will need staff to work. Terms around time off on bank or public holidays should be set out in the contract, and whether the day counts towards annual leave entitlement or is in addition to that. And where an employee is on statutory minimum holiday, so including public or bank holidays, the worker must get an alternative day off where they work the public or bank holiday. So whether workers are entitled to time off on public or bank holidays is really dictated by that contract of employment. And as I said, a recap, there's no automatic right to time off on a public bank holiday. It is really down to the nature of the business, and terms around time off on bank holidays or public holidays should be set off as you mean to go on in the contract. And some employers will require their workers to take the day off out of their entitlement, but they need to write that down. Some require them to work, and some are happy to allow workers to work and then take an alternative day off. But some businesses still do close on a bank holiday. So, contractual entitlements. Employers can give workers additional leave in excess of their statutory minimum. And this is good recruitment and a good retention tool. It's good when you have you're trying to keep people and you reward people when they've been there for like a length of period. The statutory rule only applies to the minimum 5.6 weeks. So employers can generally set their own rules for the excess leave. This could be, for example, that annual leave entitlement will be reduced if an employee commits a disciplinary offence. But you cannot do this with the statutory minimum amount. So of course, employers, you do give workers entitlement in excess of the statutory minimum. And this is often used as good recruitment, good retention. It's used as, a reward for length of service. So what we need to do is remember that there's all sorts of other terms and conditions in place in contracts for holidays. So where you buy it back if it's over, and carrying that over as well, which we cover later on. So what can employers do? What you need to do is decide when their leave year runs from, refuse annual leave requests, outline when leave can be taken and outline when leave cannot be taken. It's your business at the end of the day, isn't it? Look at when you're busy, look at when you're quiet, specify how it is taken. So it must be in a minimum blocks of 1 day. So there's lots of manufacturing firms out there that have a shutdown, for example. They make their staff take 2 weeks or 3 weeks in the summer months. And during that time, they bring in all the service industry to do all the painting, the maintenance, the engineering, the checks, etc. during this time. And it allows them to do that. You can enforce leave as well. So if you're having a quiet time and you want people to take time off, you saw this in the last credit crunch where the car trade, they force people to take the holidays, decide how many people can be off at one time, decide how much leave can be taken at one time, and cancel a period of leave that the worker has booked. So contrary to popular belief, workers do not have a right to take annual leave whenever they want. They must request annual leave, and by implication that means that that you have the right to turn down that request. You also have a lot of other types of control when it comes to annual leave, such as what I've just said before. Although the regulations allow you to cancel a period of annual leave which has already been booked, it is likely to cause complications with the employee. We're only human at the end of the day, so they may well have booked a holiday abroad and made other arrangements to spend their time, so they're not really going to be very happy. So if annual leave is cancelled without a good business reason and the employee suffers financial loss, there may be a cause for a claim of constructive dismissal. So you should tread carefully here. However, I do think out there that you are reasonable. Consider all the options first and then make a decision, but please take advice from us first too before you make that decision. So what can't employers do? You can't pay in lieu of statutory minimum unless on termination, require a minimum length of service before annual leave starts to accrue, and you can't allow a carryover of more than 1.6 weeks in normal circumstances. So that's above the 4 points, the 4 being what the working time regulation says people have to have. So where workers wants to take leave, they must give notice of twice the length of time they want to take. I want to take a week, you have to give us 2 weeks notice. For an employer to cancel booked leave, they must give notice equal to the amount of time requested. And if the employer wants to specify a period where no leave can be taken, they can do this, but they should set this out within the holiday rules or policy. So what it says with the employer notice is that regulations say that it should be twice as long as the time off they want. So for example, if the employee wants a week off, then they should give you 2 weeks notice. But what we've got to remember that in the first year of employment, the amount of annual leave the worker can take is restricted to the amount they've accrued at that point. And when it comes to employees just deciding that no leave will be permitted, it may be that they want to do it when they know they're going to be really busy, for example. So these are notice periods that are set out by the regulations. So however, employers can decide to have these ones or have different ones, which could be longer or shorter. And there are clear advantages of having longer periods of notice because you can plan, especially for the employer who will be able to plan better in busiest periods. And where these notice periods are changed, though, the period in use must be set out in the written contract of employment. So what you have is you're in the position where you can assign periods of leave to workers for the whole year, and that's really what happens in schools. After all, it happens in a factory environment. However, you should always need to build in some flexibility in case a worker needs some urgent time off. And I don't think that you would. I think we've always felt like that. All of us have felt that we could do with a couple of days holiday, a day off, or and you might just say, could I have the day off tomorrow or next week? And I don't actually think a reasonable employer, if anybody else isn't off, I don't think they'd refuse that. So urgent time off, which is best taken as annual leave rather than anything else, really, because that's what can happen, can't it? If you refuse it, somebody might go, oh, I'm taking it as sick as well instead. So then we get to carrying leave over. So annual leave entitlement is generally broken into 3 parts. We've got the basic 4 weeks under EU law. We've got the additional, the 1.6 weeks under UK law, and then contractual, which is anything above and over the 5.6 weeks. So it could be quite a complicated area of annual leave. So additional leave, the contract for these purposes will include in the statement of main terms, the handbook, the workforce agreement, collective agreement, or just anything other legally enforceable agreements, or even a letter stating that the employer agrees to the worker carrying over leave. So that's the only leave that you can carry over. Contractual leave is leave which is purely at the discretion of the employer in terms of carryover. And when carryover is allowed, the employer must actually stipulate a time limit by which the carried over leave must be used. So if you don't carry it over, it's lost within 3 months in the new leave year, because we can, carry on accruing it. It just gets too much. Because the 4-week basic leave cannot be carried over, it is seemingly a situation of use it or lose it. If the worker does not take this element of their leave, then they will lose it. If there is no relevant agreement allowing carrying over the additional 1.6 weeks, then that will also be lost if the worker has the opportunity to take it but does not. So let me just explain this clearly, okay? Basic 4 weeks under EU law, that's part of the working time regulations and working time directive. That should not be carried over because that's there for somebody's mental health. Anything above the 4 weeks, so the 1.6 weeks under UK law, if you want and allow people to carry that over, you have to have a written agreement in place to allow them to do that. And it might be a very good idea to say they lose it after so many weeks or months. Contractual is anything over the 5.6 weeks. So that would mean that if I have accrued anything other than that, which is part of my contract, which is a retention tool, then that's up to you what you write in there. But make it so it's easy to manage and that people might have the option of buying that back. That's a really good benefit. So interaction of sickness and annual leave. The European Court of Justice has been busy over the last 10 years making important judgments on what happens to annual leave when a worker is on sick leave. So basically, the ECJ has decided that annual leave is an enshrined right and workers will maintain the right to take annual leave when are prevented from taking it. So I think we should have a look at what this means in practice. Okay. So does annual leave accrue during sickness absence? Yes, it does. Regardless of the length of sickness, annual leave will continue to accrue at the rate stipulated in the contract. An interesting case to look up on CIPD HR Inform and for your knowledge is Stringer versus HMRC. So what happens when a worker, too much of the Walking Dead there, isn't it? Zombies. So what happens when a worker falls sick before pre-booked annual leave? They can reschedule the lost holiday if they want to, and the time will be converted to sick leave. So look at that case on CIPD as well, the Parader case. So what happens when a worker falls sick during annual leave? They can reschedule the lost holiday if they want to, and the time will be converted to sick leave. Workers must comply with sickness notification procedures if they wish to convert the time to sick leave. So that would go back to what you notification, and sick notification. It would also go back to providing a fit note, for example. So let me give you an example. So this means that if someone is off for the first 6 months in the leave year and then comes back, they will still have the whole year's annual leave to take in the second 6 months. So that just gives you an idea. And the reason for this, the ECJ said, is that annual leave and sickness absence have different purposes. Sick leave is for recuperation and annual leave is for rest. You cannot be on annual leave and sick leave at the same time. So can an employee on sick leave book a period of annual leave? Yes. Again, we refer to this case with the HMRC. A worker may want to do this to supplement their income if they are only receiving SSP, or because sick pay, contractual or SSP, has ended. If they wanted to do this, they would request leave in the normal way. And obviously, this is subject to the approval of the employer as normal. So a lot of you will be thinking, I didn't know that. And it's quite interesting to know that. It might be in an employer's best interest to approve the request to reduce the total amount of absence from the business overall. It also reduces the impact of holiday carryover. So we've got a next question, and this might answer That's why I've not clicked on the question box, because I knew there would be questions. But always with holidays. I will never ever do a seminar on holidays, because you just get bogged down in different contracts that people have, and it actually gets really complicated. So what I've done here is we've stuck questions at the end, because we feel these are the ones that people are going to ask. And I think if there is any other questions from this webinar, you have the access to us to answer those questions for you. So does a worker have the right to carry annual leave from one year to the next when they have been on sick leave? Yes, but this is restricted to the statutory minimum, so it's the 4 weeks. They do not have to make a request for this to happen. So if we look at the NHS Leeds versus Lana case, another worthy case to look at on the CIPD, employers can place their own limit on how long the carryover period can be, but it must be longer than a year. So 15 months has been held to be an acceptable sort of goalpost. Even if no period is stated in the contract, a period of 18 months can be applied, starting when the end of the leave year in question, after which entitlement is lost. However, if employees return to work before the end of the holiday year, but fail to take the holiday during the remainder of the year, when they had the opportunity to do so, they would lose this right to carry over. Now we look at maternity leave. So as with sickness absence, annual leave continues to accrue during maternity leave. This also applies to other types of family-related leave, and discuss with the employee before she goes, or the person, I would say now is more up to date, discuss with the employee before the person goes on holiday and maternity leave, what the person would like to do with annual leave. The ECJ indicates that public and bank holidays should be treated in the same way as other annual leave in this regard, and not allowing carryover leave may risk a claim of sexual discrimination. So because maternity leave can be lengthy and can actually straddle 2 leave years, it is advisable to discuss with the employee what they would like to do with their annual leave before they go on maternity leave. So I think that's a good thing anyway. I've had 4 children, as you know, and it is awful. I don't mean it's awful having 4 children, maybe, but before they go on maternity leave, it's nice to have that sit down, isn't it? It's nice to speak to somebody and let them know how how valuable they are to your business, because I know that actually giving birth and having children, even adopting children or fostering them, because my mum did that, it takes it out of you. And mentally, you can get paranoid, you can get hormonal, not everybody, but you can feel left out. And it takes you, a few minutes to get back in work. You feel like actually, it feels like I've never gone. But I think it's nice to have that conversation to somebody before they leave about what their rights are regarding annual leave. And, it is a financial strain, because everybody's human, and we sit there and work out what we're entitled to, and whether, how much money and how we've got to cut a cloth accordingly when we have children or bring them up. And it's nice to know that actually we can accrue holidays, and that we can bolt it on to the end of our maternity leave, and or take it as a financial, depending on what your contract says. But I would actually have that conversation with somebody if they're on maternity leave. And it also, you've heard me talk about employee engagement, haven't you, before? That is employee engagement. So where pay is the same each week, a week's holiday pay is the worker's usual pay. So where pay differs, example, variable hours or output work, a week's pay is determined by working out the average pay over the previous 12 weeks in which work was done. Case law over the past few years has shaped holiday pay in the areas of overtime and commission. Oh my gosh, that was a really dragged out case, wasn't it? The 12-week reference period to calculate holiday pay will be extended now to 52 weeks from the 6th of April 2020. So a worker is entitled to a week's pay for a week's leave. So Harper Trust found that holiday pay for part year workers should be calculated through averaging weekly pay over the previous 12 weeks. This was because part year workers are on permanent contracts, and it was reasonable to fix the quantum of holiday entitlement. It is therefore does not matter that the worker only works part of the year. So if you do want to see the Harper Trust decision, The briefing note that you're actually looking for is 234 on the CIPD HR Inform platform. So holiday pay and overtime. Overtime is generally split into 3 types. So we've got voluntary. The worker is free to turn it down, i.e. overtime is or may be offered on a weekly basis. If you wish to undertake overtime, please let your line manager know, type of thing. Not guaranteed or non-guaranteed. Employer may not necessarily know when they will offer overtime, but when it is offered, the worker is contractually obliged to do it, i.e. due to the needs of the business, you may be required to work overtime. So, for example, if I produce spring water and I don't know, I was thinking of a spring water. I was gonna, well, anyway, a spring Hilden Water, for example, if their machine collapsed and they rang me up, BA, British Airways, and said, oh, can you provide 10,000 bottles of water? I'd be thinking, yes, brilliant, get in there, you know. And as a company, I would then require my staff to work overtime to meet the needs of the business to send those bottles out overnight, for example. Contractual guaranteed. Overtime is always offered and the worker is contractually obliged to do it, i.e. your normal working hours are 9 a.m. till 5 p.m. Monday to Friday, but you will also work overtime on Saturday mornings from 8 a.m. till 11 a.m. So these are the 3 types of overtime that have been tested by the tribunal, and it is likely that your overtime practices will fall into one of these. The key with this, on the note I'd make really on non-guaranteed, so that's the one in the middle. The key with this is that the worker is required to do the overtime when it is offered. It may also be ad hoc, but the important element is that the worker must do it contractually. So then we've got holiday pay and overtime. Contractual guaranteed overtime must be included in holiday pay. And if pay differs because of the amount of contractual overtime performed, the 12-week average calculation must be performed to be extended to 52 weeks from the 6th of April, as I said, 2020. So then we've got non-guaranteed. So the Employment Appeal Tribunal found that the normal non-guaranteed overtime must be included in holiday pay. There is no definition of a normal, but a general rule of thumb is that it occurs in each pay period. It is only payable for the first 4 weeks of annual leave in a leave year, and pay for the remaining leave can be calculated excluding overtime payments. Told you it gets complicated. And then we've got voluntary overtime. Court of Appeal has determined that sufficiently regular and settled voluntary overtime must be included in a holiday pay. Again, a case worth looking at is East of England Ambulance Service NHS Trust versus Flowers. This decision is now binding case law precedent for the first 4 weeks of annual leave in a leave year. In Northern Ireland, there is a binding precedent that a voluntary overtime must be included in holiday pay. And then we've got individual results-based commission. So following this long running battle, it is now the position, actually I got bored of waiting for the decision, I'm sure you did. It is now the position that employers must include commission in their holiday pay. Case law confirms that commission is restricted to individual results-based commission, so excludes profit share and other non-individual schemes. It is only payable for the first 4 weeks of annual leave in a leave year. So always remember that 4 weeks. Pay for the remaining leave can be calculated excluding commission payments. There are still many unanswered questions in relation to this area of law, so specific advice is really recommended. So we then have upon termination. So employers cannot pay in lieu of statutory minimum annual leave except on termination. Workers have a right to be paid on an amount equal to the annual leave they have accrued, but not taken when they leave, even in cases of gross misconduct. Employers can consider enforcing annual leave during the notice period to reduce or extinguish any remaining holiday pay upon termination, but that's subject to notice requirements, again, contractual terms. Employers can reserve the right to deduct money equal to overtaken annual leave. And then we've got the impact of Brexit. So The Working Time Directive is a piece of EU law. The European Union Withdrawal Act 2018 replicates EU laws into UK law after the exit, which means business as usual. A lot of good legislation from the EU. However, this does not rule out future holiday changes. The amount of paid annual leave is not likely to reduce. The UK already gives 1.6 weeks more than the EU minimum, so it isn't going to change, is it? And imagine if it did. The area to watch is holiday pay calculations, though. The impact of the overtime and commission cases may be reversed. So all those years of waiting. So frequently asked questions, do I have to blend my annual leave rules for long holidays related to religion? So not necessarily, although a decision not to allow a longer period of leave may constitute religious discrimination, provided you are able to objectively justify a refusal, you will not be acting unlawfully. And let's remind you, there's 85 recognised religions in the UK. How does an annual leave sellback scheme work? Sellback schemes allow workers to reduce the annual leave entitlement and receive the equivalent amount of money. Example, sell 2 days back and receive 2 extra days pay. Remaining entitlement cannot fall below 5 working weeks. So these schemes can only be used for additional contractual work. So anything above the 5.6 weeks, which I did state earlier on, if you were listening properly. So can I give more annual leave to long service? Yes, although you should consider age discrimination laws. Service-related benefits that apply a length of service over 5 years can amount to age discrimination unless the decision can be objectively justified. For example, you have a legitimate aim, retention of employees, and your means of achieving it are appropriate and necessary. So, what's an in-depth HR Informed webinar today? If you would like to attend one of our seminars, which do last for 3 hours, we hold them all over the country, contact us at CIPD HR Inform. There's lots of resources on there. So we've got employment law resource on holiday entitlement and pay, employment law resource on working time, how-to guides on encouraging annual leave take-up and managing holiday entitlement and pay, and model holiday policies, including specialist policies for Christmas leave and buying and selling holidays, model holiday request forms, acceptance, refusal, and compulsory leave notifications. We've got reports on leading case law in this area. So as I've said all the way through, there's lots of them. I know you're going to have questions. I've answered as many as I can. Questions, please email in events@hr-inform.co.uk. If you'd like to book your free CIPD HR Inform demo and get a free 24-hour trial, have a look at those case history, have a look at our letters, have a look at our policies, then contact us on 0333 207 5658 or hr-inform.co.uk. And if you are a CIPD member, you get 50% off the subscription, and it's absolutely brilliant for learning and tools. My name's Amanda Chadwick. I thank you very much for listening to me. I hope you've enjoyed today's webinar. I hope you're not getting windswept, or actually I hope you haven't got any floods in your area. But thank you so much for listening to me, and I hope to speak to you again soon. So it's goodbye from me.